The findings were found are wrong in law, are irrational, and in some instances exceed the scope of the powers of the public protector.
The then DA leader, Mmusi Maimane, laid a complaint under the Executive Ethics Code with Busisiwe Mkhwebane after President Ramaphosa responded to questions in the National Assembly from Maimane about a 500,000 rand payment, that it was one linked to the CR17 campaign, Ramaphosa's election campaign, and that money had been paid by now deceased Bosasa CEO Gavin Watson to Ramaphosa's campaign. Maimani's complaint was essentially that Ramaphosa had lied to Parliament and thus breached the Executive Ethics Code. The Public Protector then investigated those claims and released a very damning and far-reaching report into the President's campaign finances, but also demanded that the President disclose all his funders in Parliament.
I have concluded that the report is fundamentally and irretrievably flawed. This is strongly confirmed by my legal representatives, who have equally studied the Public Protector's report very thoroughly.
All of those things remain sealed, so we don't actually have access to them. However, media leaks at the time that all of this drama was playing out in the public sphere have suggested that the emails, for example, show that Ramaphosa may have known more than he said he did about the identity of the campaign funders, which is something that he said he kept a distance from. The Public Protector has already had several damning court judgments made against her, questioning her honesty, her impartiality, her understanding of her job. On the other hand, Ramaphosa is leading a split and fractionalized ANC, which is very ideologically skewed in different directions, and where he and Pravin Gordhan have come under fire from certain factions as being, aligned to particular global financial interests. So if those kind of issues, the identities of his donors come out, they could be utilized as ammunition, not so much on a legal basis, but probably more likely on a political basis.
I have decided to take this action not only to protect the rights that the Constitution affords me as a person, but also to preserve the integrity of the office that I occupy.
The Public Protector says that her investigation into Ramaphosa is about accountability. However, the President's lawyers say that she wasn't entitled to do this investigation. This is going to be one of the pivotal issues that the court ultimately has to determine when it reaches its judgment, as to exactly what the Public Protector was entitled to investigate.
The Public Protector has violated the provisions of the Public Protector Act, the Constitution, and the principles of our common law.
The Public Protector has launched far-reaching legal action against the National Assembly, which is currently considering whether she should face a potential inquiry into her fitness to hold office. One of the grounds that she raises in that inquiry is that it is completely untenable that the President should have the power to suspend her. She says that he is clearly conflicted and that it is inappropriate for him to be given that power to do so. That court case is expected to be heard in March, and it will also have implications potentially, given the possibility that the court may reach a determination in the same time period as this potential inquiry goes ahead, or the litigation to stop it proceeds.
I've decided to take this action not out of disrespect for the Public Protector as a crucial institution of our democracy, but in the expectation that the institution will ultimately be strengthened by an independent and impartial judicial review.